Flammur Schala, Fokus Strategie GmbH, Sonntag, 16. Januar 2022. Stojan Župljanin was born on 22 September 90. The trial chamber now turns to the question of whether the accused in this case were members of the joint criminal enterprise. Stojan Župljanin was born on 22 September 1951 in the village of Maslovare, in the municipality of Kotor Varoš. In 1975, after graduating from law school, he started a career in the police. During the indictment period, he was chief of the Banja Luka Security Service Center of the Ministry of Interior of the Serbian Republic, otherwise known as the Banja Luka CSB. By 6 May 1992, the CSB had in its areas of responsibility the CGBs of all of the municipalities that were part of the autonomous region of Krajina or ARK. While there is no evidence that Župljanin was a member of the Serbian Democratic Party, he undoubtedly had strong ties to it. As the highest police authority in the ARK, Župljanin had the legal duty to protect the entire civilian population regardless of religion, ethnicity, race or political beliefs. On 5th of May 1992, Župljanin became a member of the crisis staff of the ARK. From April until the end of July 1992, Župljanin issued several orders to his policemen to follow the instructions of this regional body. Those orders included the disarmament of Muslims and Croats and restrictions on the amount of currency and valuables that could be brought out of the ARK. Stojan Župljanin, in concert with the Banja Luka TO and members of the Serbian Democratic Party and the ARK, was one of the key actors behind the organization of the blockade of Banja Luka on 3 April 1992. When the non-Serb community in Banja Luka demanded police protection, Župljanin either provided false assurances or openly refused it. In addition, Župljanin dispatched his policemen, including the Banja Luka CSB Special Police Detachment, to disarm the Muslim and Croat population and to participate with other Serb forces in the takeover of municipalities in the ARK. While engaged in these operations, Župljanin's Special Police Detachment, which he had created and staffed with Serb nationalists, some of whom with prior criminal records committed heinous crimes against Muslims and Croats, including rape, torture and murder. Župljanin, despite being repeatedly informed of the crimes of this special unit, continued engaging it in operations in close contact with Muslim and Croat civilians, whom the detachment continued to abuse. Župljanin was also aware of the unlawful arrest and detention of thousands of Muslims and Croats in the ARK, that's the autonomous region of Krajina. Of the harsh conditions in which they were interned and of the abuses and other crimes that were cruelly inflicted upon them. In spite of this knowledge, Župljanin continued engaging his policemen in guarding the unlawfully detained prisoners and ordering the transfer and transportation of detainees from police-controlled facilities to the Manjača or the Manjača camp. Župljanin did issue a number of orders exhorting IRK policemen to respect the law, but these orders were ineffective and, as found by the trial chamber, not genuinely meant to be effectuated. Notably, on 20 July 1992, Župljanin proposed to Stanišić to treat unlawfully detained non-Serbs as hostages and to exchange them for Serb prisoners. In spite of his extensive knowledge of the commission of crimes against non-Serbs, including by his subordinates, Župljanin failed to investigate these crimes or to discipline the perpetrators. In relation to at least 2 incidents where large numbers of Muslims were killed by members of the police, Župljanin misled the judicial authorities in an effort to shield the perpetrators from criminal prosecution. The trial chamber finds beyond reasonable doubt that through these acts and omissions, Stojan Župljanin both intended and significantly contributed to the plan to remove Bosnian Muslims and Bosnian Croats from the territory of the planned Serbian state. Moreover, the crimes that the trial chamber has found fall outside the plan, such as murder, extermination, unlawful detention and torture, more foreseeable to Župljanin, and torture were foreseeable again. Moreover, the crimes that the trial chamber has found fall outside the plan, such as murder, extermination, unlawful detention and torture, were foreseeable to Župljanin. The chamber has examined the evidence linking the physical perpetrators to members of the GCE, that's the Joint Criminal Enterprise, and finds that the crimes committed to the ARK municipalities, the Autonomous Region of Krajina municipalities, are imputable to at least one member of the GCE and thereby to Stojan Župljanin. Mićo Stanišić was born on 30 June 1955 in the village of Ponor, in the municipality of Pale. In 1973, he commenced work with the SUP in Sarajevo. The SUP, that's the SUP, unutarnja poslova, SUP je Sarajevo, unutarnja poslova. I'm not sure what the meaning of SUP is. He commands work with the SUP in Sarajevo and became an inspector after graduating from law school in 1982. Stanišić attended the first meeting of the Council of Ministers of the Bosnian Serb Assembly. At this meeting, the demarcation of the boundaries of ethnic territory for the Serbs was the priority, as well as the establishment of governmental organs in that territory. Stanišić was involved in the establishment of the SDS and worked to promote and implement its policies. During the indictment period, he was the Minister of Interior of the self-proclaimed Republika Srpska, as the highest authority in the Republika Srpska on matters of interior affairs. Stanišić had the legal duty to protect the entire civilian population, regardless of religion, ethnicity, race, or political beliefs. Stanišić shared a close relationship with Radovan Karadzic and other leading members of the GCE. And he was a key member of the decision-making authorities from early 1992 onwards. Stanišić had overall authority over the police forces of Republika Srpska and employed the internal affairs organs in accordance with the police and decisions adopted by the Presidency, the National Security Council, and the Bosnian Serb Assembly, or BSA. And the BSA, his conduct, presence at key meetings, attendance at sessions of the BSA, and acceptance of the position of Minister of Interior all indicate his voluntary participation in the creation of a separate Serb entity within Bosnia and Herzegovina by the ethnic division of the territory. Territory. Division of the territory, by the division of the territory. Again, Stanišić had overall authority over the police forces of Republika Srpska and employed the internal affairs organs in accordance with the policies and decisions adopted by the Presidency, the National Security Council, and the Bosnian Serb Assembly, or BSA. His conduct, presence at key meetings, attendance at sessions of the BSA, and acceptance of the position of Minister of Interior all indicate his voluntary participation in the creation of a separate Serb entity within Bosnia and Herzegovina by the ethnic division of the territory. To this end, Stanišić made active police forces reinforced with unqualified reserve policemen available for coordinated action with the armed forces in order to effect ethnic division on the ground. Despite being aware of the commission of crimes by these joint forces, Stanišić consistently approved the deployment of his police forces in this manner. He also permitted the continued use of reserve forces by the army, primarily for the purpose of guarding prisons and detention camps. Stanišić only sought to withdraw regular policemen from combat activities toward the end of 1992, when most of the territory of Republika Srpska had been consolidated. The trial chamber received evidence that Mićo Stanišić issued orders in the course of 1992, particularly between the months of July and August, for the protection of the civilian population. Issued orders. However, Stanišić failed to use the powers available to him under the law to ensure the implementation of these orders, despite being aware of the limited action taken subsequent to his orders. Moreover, the orders in relation to detention camps were prompted by the scrutiny of the international community, and were mostly concerned with the image of Republika Srpska in the eyes of the world. By failing to remove errant personnel from the police forces, Stanišić violated his professional obligation to protect and safeguard the civilian population in the territories under their control. The fact that Mićo Stanišić had the ability to do more is borne out by the decisive manner in which he pursued the theft of Golf vehicles from the RSMUP and the harassment of local Serb leaders by paramilitary groups after the outbreak of hostilities. The trial chamber finds beyond reasonable doubt that through these acts and omissions, Mićo Stanišić both intended and significantly contributed to the plan to remove Bosnians, Muslims and Bosnian Croats from the territory of the planned Serbian state. So, perhaps what so the main accusation so the accusation or the plan was so the plan was to remove Bosnian Muslims and Bosnian Croats, or Bosnian Muslims and Bosnian Catholics. Plan was to remove Muslims and Catholics from Bosnia. The Muslims are called Bosnian Muslims. The Catholics are called Bosnian Croats, or just Croats, moving Croats out of Bosnia and moving Bosnians out of Bosnia. Muslim Bosnians and Catholic Bosnians. And the Catholic Bosnians are Croats. From the territory of the planned Serbian state, because the plan was a Serbian state, or that plan was that the Bosnian territory becomes Serbian. Moreover, the crimes that the trial chamber has found fall outside the plan, such as murder, unlawful detention and torture, were foreseeable to Stanišić, except for the crime of extermination, which will be dealt with in a moment. The chamber has examined the evidence linking the physical perpetrators to the members of the GCE and find that the crimes committed in the municipalities, save for the appropriation of plunder of property and wanton destruction in Bileća, are imputable to at least one member of the GCE and thereby to Mićo Stanišić. With respect to the crime of extermination, the chamber reviewed the evidence on Stanisić's responsibility for this crime, pursuant to the remaining modes of liability charged in the indictment. With regard to the incidents of extermination in the municipalities of Ključ, Kotor, Varoš, Prijedor, Brčko, Visegrad, Vlazenica, Zvornik and Banja Luka, the trial chamber finds that Stanišić is not criminally responsible for instigating the crime of extermination, nor is he responsible for aiding and abetting this crime. The trial chamber further analyzed Stanisić's liability for extermination under the doctrine of command responsibility and finds that he either did not know or did not have reason to know that extermination was being or had been committed. In the case of Korycanske Stijene, although Stanišić did come to know of the extermination of over 150 Muslim men within 50 days of the crime, the trial chamber finds that he does not bear criminal responsibility for these crimes because the prosecution failed to prove that Stanišić failed to take necessary and reasonable measures to punish the perpetrators in relation to this incident. This completes the summary of the findings of the trial chamber. I will now read out the disposition of the trial chamber as contained in the written judgment. Will the accused Mićo Stanišić please rise? For all the foregoing reasons and pursuant to Articles 23, 24 and 27 of the Statute of the Tribunal of Rules and Rules 98, 101, 102, 103 of the Rules of Procedure and Evidence of the Tribunal, the trial chamber hereby decides as follows. The trial chamber finds you, Mićo Stanišić, to be guilty. So, Mićo Stanišić, the Minister of Interior, is guilty pursuant to Article 7 in Glamre Eis of the statute of the following counts. Count 1. Persecution as a crime against humanity through the following underlying acts. So, crime against humanity and persecution. Persecution through killings. Or persecution, killings, torture, cruel treatment and inhuman acts. They go together with torture. Then unlawful detention. Unlawful detention, then establishment and perpetuation of inhuman living conditions. And perpetuation of inhuman living conditions. Forcible transfer and deportation, plunder of property, wanton destruction of towns and villages, including the destruction or willful damage done to institutions dedicated to religion and other cultural buildings. So, destruction. Imposition of maintenance of restrictive and discriminatory measures. So, discrimination or discriminatory measures. Count 4. Murder as a violation of the laws of customs of war. Count 6. Torture as a violation of the laws of or customs of war. In relation to the following counts, on the basis of the principles relating to cumulative convictions, the trial chamber does not enter convictions. Count 3. Murder as a crime against humanity. Count 5. Torture as a crime against humanity. Count 7. Cruel treatment as a violation of the laws of customs or customs of war. Count 8. Inhuman acts as a crime against humanity. Count 9. Deportation as a crime against humanity. Count 10. Inhuman acts, forcible transfer, as a crime against humanity. The trial chamber finds Mićo Stanišić to be not guilty pursuant to Articles 7(1) and 7(3) of the statute of the following count. Count 2, extermination as a crime against humanity. The trial chamber hereby sentences Mićo Stanišić to a single sentence of 22 years of imprisonment. Mićo Stanišić has been in custody since 11th March 2005. And pursuant to Rule 101C of the rules, he is entitled to credit for time spent in detention thus far. Pursuant to Rule 103C of the rules, Mićo Stanišić shall remain in the custody of the tribunal pending the finalization of arrangements for his transfer to the state where he shall serve his sentence. You may now be seated. So, he got a sentence of single sentence of 22 years imprisonment. And then the other one. Stojan Župljanin, Chief of Regional Security Service Center of the Autonomous Region of Krajina. Will the accused Stojan Župljanin please rise? The trial chamber finds you, Stojan Župljanin, to be guilty pursuant to Article 7(1) of the statute of the following counts. Count 1. Persecution. Killings, torture, cruel treatment and inhuman acts unlawful detention, establishment and perpetuation of inhuman living conditions, forcible transfer and deportation, plunder of property, wanton destruction of towns and villages, including destruction or willful damage done to institutions dedicated to religion and other cultural buildings. Destruction. Let's call it destruction. Imposition and maintenance of restrictive and discriminatory measures. Discrimination as discriminatory measures. Count 2, extermination as a crime against humanity. Count 4, murder as a violation of the laws or customs of war. Count 6, torture as a violation of the laws or customs of war. In relation to the following counts, on the basis of the principles relating to cumulative convictions, the trial chamber does not enter convictions. Also, the trial chamber does not enter convictions. Count 3, murder as a crime against humanity. Count 5, torture as a crime against humanity. Count 7, cruel treatment as a violation of the laws or customs of war. Count 8, inhuman acts as a crime against humanity. Count 9, deportation as a crime against humanity. Count 10, inhuman acts, a forcible transfer, 2, as a crime against humanity. And the trial chamber hereby sentences Stojan Župljanin to a single sentence of 22 years of imprisonment. Stojan Župljanin has been in custody since 11th June 2008. And pursuant to Rule 101C of the rules, he is entitled to credit for time spent in detention thus far. Pursuant to Rule 103C of the rules, Stojan Župljanin shall remain in the custody of the tribunal pending the finalization of arrangements for his transfer to the state where he shall serve his sentence. You may now be seated. The registry shall now distribute copies of the written judgment to the parties. The trial is now completed and this hearing is adjourned. So that was the one of the judgment summaries from the International Criminal Tribunal for the former Yugoslavia. I will read all the judgment summaries from the International Criminal Tribunal for the former Yugoslavia. I started now with one text and then I will read every one of them so that I will have a playlist including all those judgment summaries.